General Provisions. Section 241. Recovery for wrongful death. Whenever the death of a person shall result from an injury inflicted by negligence or wrongful act, then, in every such case, damages may be recovered for such death, from the corporations and persons so causing the same. Until otherwise provided by law, the action to recover such damages shall in all cases be prosecuted by the personal representative of the deceased person. The General Assembly may provide how the recovery shall go and to whom belong, and until such provision is made, the same shall form part of the personal estate of the deceased person. In the path-breaking case of Carey v. Berkshire Railroad, 1848, the Massachusetts Supreme Judicial Court ruled that the survivors of a person who had been negligently killed had no cause of action against the homicidal person or corporation. In 1853, the Kentucky Court of Appeals adopted the rule announced in Carey, the wrongful death rule, in the case of Eden v. Lexington and Frankfort Railroad Company. Although the General Assembly in 1854 had abolished the wrongful death rule, the Kentucky Court of Appeals ruled in 1887. In Henderson's Administrator v. Kentucky Central Railroad Company, that under Kentucky statute, only spouses or children of the victim could recover damages for wrongful death caused by willful neglect. During 2 sessions of the General Assembly that followed the Henderson case, the Senate enacted a bill that in effect overruled that decision by giving the deceased's personal representative the right to recover damages for the estate for wrongful death, but the House failed to pass the bill due to effective politicking by the railroad lobby. In response to these 2 decisions, and because of a lack of confidence in the willingness of the legislature to remedy the problems, in Section 241 the framers of the current Constitution gave the personal representative of a person who was wrongfully killed a constitutional right to sue for damages and provided that any damages recovered would form a part of the deceased's personal estate. This provision thus establishes an unlimited right of recovery for wrongful death rather than one limited to immediate family members. The General Assembly has chosen not to change the procedure for wrongful death litigation, opting instead for the constitutional provision that personal representatives have the exclusive right to sue and that recovered damages should go into the personal estate of the deceased person. The Kentucky judiciary has held that Section 241 does not violate the federal 14th Amendment even though it provides for recovery that may benefit persons who have no pecuniary interest in the life of the deceased. Owensboro and Nashville Railway Company v. Barkley, 1897. It is also ruled that an employee's election to be bound by the Workers' Compensation Act eliminates the right of his or her personal representative to recover damages for his or her death. In Granison v. Bates and Rogers, 1920, the judiciary has used Section 241, together with Sections 14 and 54, to invalidate legislation that abolished or curtailed rights of action for damages for death or injuries caused by negligence. It is ruled that a statute that purported to extend sovereign immunity to physicians at a state university hospital in Gould v. O'Bannon, 1989, a statute that prohibited recovery from an automobile owner for the negligently caused death of his guest in Ludwig v. Johnson, 1932, and a statute that cut off suits against builders and materialmen after 7 years. In Perkins v. Northeastern Log Homes, 1991, all violated Section 241.
Section 242. Just compensation to be made in condemning private property, right of appeal, jury trial. Municipal and other corporations, and individuals invested with the privilege of taking private property for public use, shall make just compensation for property taken, injured or destroyed by them. Which compensation shall be paid before such taking, or paid or secured, at the election of such corporation or individual, before such injury or destruction. The General Assembly shall not deprive any person of an appeal from any preliminary assessment of damages against any such corporation or individual made by commissioners or otherwise. And upon appeal from such preliminary assessment, the amount of such damages shall, in all cases, be determined by a jury, according to the course of the common law. The principal purpose of Section 242, which was newly inserted into the current Constitution, was to confer on the owners of property that was injured or destroyed by public improvement a right to compensation from the city or corporation that caused the injury. Proponents of Section 242 argued that it was necessary, because the Section 13 declaration that property shall not be taken for public use without compensation did not adequately protect against indirect injury to property not formally condemned by the process of eminent domain. They also pointed out that many of the new state constitutions, especially that of Pennsylvania, contains similar provisions. Detractors contended that Section 242 would impede public improvements because it would allow nearby landowners to secure damages for necessary and rather remote injuries to their property or, worse, to stop improvements altogether because of these injuries. Section 242 has been the subject of much published litigation. The Kentucky judiciary has ruled that Section 242 subjects not only cities, but also counties to liability for damages to private property by public works projects, in Lehman v. Beeler, 1902. Section 242 abolishes the requirement of a direct physical injury to the property in order to establish a claim for damages, in City of Henderson v. McLean, 1897, although not all interference with private property constitutes a violation of Section 242. For example, landowners cannot recover damages for temporary interference with the egress and ingress to their property while a road in front of it is being constructed, in Mercer County v. Ballinger, 1931, but they can recover from a railroad that permanently blocks the egress and ingress to their property as well as for damages caused by noise and smoke of its trains, in Maysville and Big Sandy Railroad Company v. Connor, 1895. Section 242 does not require compensation for environmental damage beyond that provided in federal statutes. In Profits v. Louisville and Jefferson County Metropolitan Sewer District, 1993. Just compensation for a taking of land is its value at the time of the taking, in Brock v. Harlan County, 1944, and the amount of recovery for damage to land by construction cannot be offset by the value of benefits to that part of the land not damaged, in Howard v. Howard, 1935.
Section 243. Child labor. The General Assembly shall, by law, fix the minimum ages at which children may be employed in places dangerous to life or health, or injurious to morals, and shall provide adequate penalties for violations of such law. The framers of the current Constitution inserted Section 243 in response to a request from a delegation of labor union representatives, which appeared before the committee that drafted the general provisions. By 1891, most states had by statute prescribed a minimum age for employment in dangerous places, and in the early part of the 20th century they began to prohibit child labor altogether except for summer or part-time work in non-dangerous environments. The delegates considered Section 243 to be an inducement for parents to send their children to school. Although some complained that it might compromise the necessary efforts of certain youth to help their impoverished families. Section 243 is another provision that mandates legislation, although it leaves it up to the General Assembly to establish minimum ages. The legislature enacted the first in series of child labor statutes in 1894. Prohibiting the employment or exhibition of children under the age of 16 in immoral, indecent, or unusually dangerous practices. The first Child Labor Act that outlawed the employment of children in industrial occupations was enacted in 1902. In one of the very few decisions concerning Section 243, the Kentucky Court of Appeals cited the provision as evidence of Kentucky's policy of special protection of minors from injury and held that a minor had a cause of action against owners of a liquor store who sold liquor to another minor who then became intoxicated and as a result lost control of his automobile, causing it to be wrecked and to injure the plaintiff, in Pike v. George, 1968.
Section 244. Wage earners in industry or of corporations to be paid in money. All wage earners in this state employed in factories, mines, workshops, or by corporations, shall be paid for their labor in lawful money. The General Assembly shall prescribe adequate penalties for violations of this section. In the 19th century, American mining companies often paid their workers in company scrip redeemable only in company-owned stores. In the latter part of the century, states began to outlaw company scrip, but attempts to do so failed in the Kentucky legislature because of the efforts of mining company lobbyists. Supporters of Section 244 argued that in Kentucky, mining companies and manufacturers of plug tobacco used the check system, which involved the payment of wages in the form of brass checks that could only be used at company stores to buy goods at inflated prices or to pay high rents for company houses. Because of the legislature's failure to outlaw this practice, reformers called for a constitutional mandate on the subject. Some opponents denied that the workers were required to accept brass checks and others defended the system as a way to prevent them from spending their wages on alcohol. Pursuant to Section 244, in 1892 the General Assembly enacted a statute that provided a fine of $500 for every violation of the section. Very few cases have originated concerning this section, and all of them occurred before World War II. The Kentucky Court of Appeals held in 1904 that Section 244 authorized the General Assembly to require mining companies to pay their employees within 15 days of the 15th and 30th of each month, in Commonwealth v. Rheinick Coal Mining Company, 1904, and prohibited a corporation from paying its wages in the form of metal checks redeemable in cash at a discount in excess of the lawful rate of interest, in Kentucky Coal Mining Company v. Mattingly, 1909. The section also renders unconstitutional a statute that permitted a company to pay wages in the form of non-transferable scrip, in Barker v. Stearns Coal and Lumber Company, 1941.
Section 244A. Old Age Assistance. The General Assembly shall prescribe such laws as may be necessary for the granting and paying of old persons an annuity or pension. In 1935 voters approved an amendment that added this section, which was proposed by the General Assembly in order for Kentucky to share in the appropriations of the Federal Social Security Act of 1935. The Social Security Act made federal payments to states for aged needy persons conditional on the states submitting plans for old age assistance to the federal government for its approval. Section 244A authorizes and mandates such a plan, which was enacted by the General Assembly in 1936. There have been no published decisions about Section 244A. The Special Commission on Constitutional Review of 1987 recommended that Section 244A be amended to read that the General Assembly may prescribe such laws as it deems necessary for the provision of public assistance to the aged, infirm, and needy.
Section 245. Revision of statutes to conform to Constitution. Upon the promulgation of this Constitution, the Governor shall appoint 3 persons, learned in the law, who shall be commissioners to revise the statute laws of this Commonwealth, and prepare amendments thereto, to the end that the statute laws shall conform to and effectuate this Constitution. Such revision and amendments shall be laid before the next General Assembly for adoption or rejection, in whole or in part. The said commissioners shall be allowed $10 each per day for their services, and also necessary stationery for the time during which they are actually employed, and upon their certificate the auditor shall draw his warrant upon the treasurer. They shall have the power to employ clerical assistants, at a compensation not exceeding $10 per day in the aggregate. If the commissioners, or any of them, shall refuse to act, or a vacancy shall occur, the Governor shall appoint another or others in his or their place. This section required the Governor to appoint a 3-member commission of attorneys charged with proposing revisions of the statute law of the Commonwealth, so that it would conform to the new Constitution, and in time for the next session of the General Assembly to consider and adopt the proposed changes. The previous Constitution contained a similar provision, although it was designed less to conform the statutes to the new Constitution and more to eliminate duplicate and redundant statutes, and to provide for codes of criminal and civil procedure. The Kentucky Court of Appeals has declared that Section 245 was intended to rid the state of special legislation, in Williams v. Knoll, 1900, and to establish a uniform system of laws throughout the state, in McHenry v. Winston, 1899. The Special Commission on Constitutional Review of 1987 recommended the repeal of Section 245.
Section 246. Maximum limit on compensation of public officers. No public officer or employee except the Governor shall receive as compensation per annum for official services, exclusive of the compensation of legally authorized deputies and assistants, which shall be fixed and provided for by law, but inclusive of allowance for living expenses, if any, as may be fixed and provided for by law, any amount in excess of the following sums: officers whose jurisdiction or duties are coextensive with the Commonwealth, the mayor of any city of the first class, and judges and commissioners of the Court of Appeals, $12,000. Circuit judges, $8,400. All other public officers, $7,200. Compensation within the limits of this amendment may be authorized by the General Assembly to be paid, but not retroactively, to public officers in office at the time of its adoption, or who are elected at the election at which this amendment is adopted. Nothing in this amendment shall permit any officer to receive, for the year 1949, any compensation in excess of the limit in force prior to the adoption of this amendment. Originally, Section 246 set a limit of $5,000 for the salaries of public officers, excluding that of the governor, who was exempted because the chief executive was thought to need more compensation in order to adequately entertain and generally to uphold the dignity of the office. The limitation was placed in the Constitution because the delegates persistently sought ways to cut the expenses of state government and specifically did not trust the General Assembly to limit salaries. They supported this conclusion by citing the annual income of the clerk of the Court of Appeals, who earned twice as much, $10,000, as the governor, and that of the jailer of Jefferson County, who reportedly earned 8 times as much, $40,000, and they ignored the fact that most public officers earned barely enough to survive. For example, circuit judges earned only $3,000 annually. In 1891, $5,000 a year constituted a reasonable governmental salary, and little in the way of inflation had occurred during the period of the Third Constitution, 1851 to 1891, a reality that perhaps excused the delegates from foreseeing the problems a fairly constant rise in prices would create. However, inflation did take hold early in the 20th century, especially during World War I, so that by 1925 the first in a series of amendments was proposed to raise the maximum amount. Voters defeated this and 3 other similar amendments, but in 1949 they approved the current section, which establishes a limit of a $12,000 annual salary for statewide officials, mayors of first-class cities, and judges and commissioners of the Court of Appeals, $8,400 for circuit judges, and $7,200 for all other public officials. In 1963, the voters rejected a proposed amendment that would have abolished the salary limit. The 2 most significant decisions concerning Section 246 held that it permits salaries to be adjusted to reflect the purchasing power of the dollar as of 1949, in Matthews v. Allen, 1962, and that it limits the salaries of only those officers mentioned in the Constitution, in Graves County Board of Education v. DeWeese, 1960. Although Section 246 as amended refers to public employees as well as public officers, the court noted in the latter decision that the ballot question presented to the voters in 1949 referred only to the compensation payable to public officers. The former decision authorized the General Assembly to annually increase the salaries of public officials to reflect the increase of consumer prices, an objective accomplished annually by general statutes, and the latter permitted a number of governmental employees not mentioned in the Constitution and therefore not covered by Section 246, such as university administrators and certain faculty, to receive compensation in excess of the maximum. The Special Commission on Constitutional Review of 1987 recommended the repeal of Section 246.
Section 247. Public printing, contract for, officers not to have interest in, governor to approve. The printing and binding of the laws, journals, department reports, and all other public printing and binding, shall be performed under contract, to be given to the lowest responsible bidder, below such maximum and under such regulations as may be prescribed by law. No member of the General Assembly or officer of the Commonwealth shall be in any way interested in any such contract, and all such contracts shall be subject to the approval of the governor. During the period of the Third Constitution, 1851 to 1891, the printing of public documents, journals, and the like was handled in one of 2 ways: by contract to the lowest bidder or by a public printer elected by the General Assembly. The majority party inevitably elected the public printer, and when that company did the public printing, it was done without competitive bidding. Not surprisingly, the contract system cost substantially less, and also not surprisingly, the frugal-minded framers of the current Constitution adopted that system as the way to handle future public printing. Pursuant to Section 247, in 1893 the General Assembly enacted the first in a series of statutes that established a process for the advertising and awarding of public printing contracts. In the few decisions about this section, the Kentucky judiciary has ruled that Section 247 does not cover incidental printing in Stone v. Dispatch Publishing Company, 1900, or the printing of ballots in Krieger v. Standard Printing Company, 1921, and does authorize state agencies to print their own forms and documents in unbound form using multilith and multigraph machines in State Journal Company v. Commonwealth, 1942.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.